Good evening. We are back as usual. Removal defense, that's the topic. We have been talking about removal defense, and yesterday the house was in fire. I can't wait for the same energy tonight. If you're here, just get in and let me know in the comments where are you calling me from, okay? Where you watching me from, where you gonna comment from, and where you wanna call me from. So we are here. Come on, let's get right into it, folks. Let's get right into it. In the comments, say hi. Yes, now we talking. In the comments, say hi. In the comments, say hi. We're gonna talk about fraud today. Misrepresentation. Okay, willful misrepresentation, and what it is, why it's important not to do it. It is the most dangerous mistake, okay, to make in immigration, because sometimes you cannot waive it. So stay away from it. Yes, if you're here, say hi in the comments, and please go ahead and like. Please go ahead and share. Don't forget, let me know in the comments where are you from, watching me from, what area. Yes, okay. Let me know so we can get started. Let me know in the comments so we can get started, okay? I'm gonna share my screen with you so we can talk about this fraud marriage, okay? Fraud marriage, the matter of SINGH and the matter of PAK. That's the topic. Let me just share my screen so we can get started, okay? Sharing this entire screen. Okay, let's start with matter of SINGH. What is the standard? Okay, this is a BI decision, right, of 2019, and that's actually give us the standard when it comes to fraud marriage. What are they really looking for in order to make it to 04C determination? Okay, so this is the standard. The standard of proof necessary to bar the approval of a visa petition based on marriage fraud under Section 204C is what is substantial and probative evidence. USCIS has to show us substantial and probative evidence, not just some allegations, right? They have to actually show it, okay? So, and the degree of proof necessary to constitute substantial and probative evidence is more than a preponderance of evidence. Preponderance of evidence is like the lowest standard, and then it's more than that, right? Substantial and probative. So it's pretty much a little bit higher, but less than clear and convincing evidence. It's pretty much in the middle. Preponderance of evidence is just like on the bottom. Substantial and probative is here. Clear, convincing is in the on the top. So in the middle, if they have something in the middle, yes, they can make a determination of fraud marriage. Okay. So, and it says that the nature, quality, quantity, and credibility of the evidence of marriage fraud contained in the record should be considered in its totality in determining if it is substantial and probative. They have to look at everything. They can't just come up with some allegations here and there. They have to look at the entire case, right? The application of the substantial and probative evidence standard requires the examination of all relevant evidence and determination as to whether such evidence, when viewed in totality, Okay, established with sufficient probability that the marriage was fraudulent. It has to establish with sufficient probability, you see. So, and then both direct and circumstantial evidence may be considered in determining whether there is substantial positive evidence of marriage fraud under Section 204C of the Act. And circumstantial evidence alone may be sufficient, right, to constitute substantial and probative evidence. You see how this fraud marriage is? Well, my friend, you gotta stay away from it. If you're filing a marriage petition, okay, green card based on marriage, you gotta have sufficient evidence. So, and you gotta be prepared for the interview as well. And if they come up with some allegations, my friend, you gotta fight it right on, because the moment you don't rebut anything, it stays in the records. Okay, so that's why then if they ask you for a waiver of fraud or misrepresentation, if there's just some lies here and there, then you can waive it. But if they make a determination under 204C, then you are barred. It's a permanent bar that cannot be waived. Okay, and that's how bad that is. You see? So then we have the matter of PAK. Give you the same thing, right? It says that where there is a substantial and probative evidence that the beneficiary for prior marriage was fraudulent and enter into the purpose of evading the immigration law, a subsequent visa petition filed is properly denied, okay? Because of insufficient evidence of bona fide marriage. Even if the first visa petition was denied. So basically, they're going to go back and look at, that's when you filed the first marriage, it didn't work out, right? You go and file the second marriage. You go and file the third marriage, green card, based on marriage. My friend, just know that they can go, based on this case here, they can go all the way back from the first marriage to make sure if there was something insufficient of a bona fide marriage. If the evidence was not sufficient, then they can make the second marriage determination as fraud, and under Section 204C, then you'll be barred from adjusting status. That's why really you gotta be careful with those petitions. Sometimes people say that marriage, a green card marriage, is the easiest application to file. My friend, if you have a valid marriage, it can be easy if you give all the evidence, okay? But if you have a valid marriage and you give insufficient evidence, then they call you for the interview, then you mess it up, just know that they can make a 204C bar determination, which is a permanent bar. So that then you find yourself in removal proceedings. Now, how are you going to defend yourself? In removal proceedings, then you have to come up with, again, a set of evidence to set the record straight and an alternative defense. But just know that if you bar here, then you can't, whatever defense you get, you're not going to get a green card because you cannot adjust status. So that's the problem. That's what I wanted to talk to you about today. Because we have 2 cases of misrepresentation pending. I'm just waiting for the result to come so I can discuss the case with you. But right now, we just wanted to talk about this one. Let me stop sharing and take some questions, okay? Yes, Gonzalez, you are here. Hi, Gonzalez. How are you? Are you liking this video? Are you sharing? Today, we don't have a lot of people. I don't know why, but they're going to come back and watch it later. But what we're talking about here, it's about fraud marriage, okay? Fraud marriage. Big no, big no, big no. Don't do it. Don't do it at all. It's not worth it. And if USCIS comes with some allegations as to fraud, you need to fight it right on, okay? Otherwise, it's going to stay in the record. And the second time you get into another marriage, maybe you got a divorce, and then you get into another marriage, it's not going to work, because then they're going to say that the first one was fraudulent and you didn't fight it. So we got 5 people here. Please go ahead and like. Please go ahead and share. Let's get some questions answered. Is joint bank account enough to prove a marriage is valid? And what happened when the U.S. citizen refused to come to the interview? Bank account is not, no, bank account alone is not enough. Kofi, Emmanuel, bank account alone is part of the evidence, but it's not enough, okay? If you go under I-130, you will see a list of evidence that is required. Just Google I-130 petition and Google instruction form. You will see the list of evidence that is required. Joint bank account, tax return filed together, affidavit from friend and family, anything that shows commingling of assets. If you have something, property together, lease agreement, you have to be able to show cohabitation, you know? So if you can't prove that, well, then it's really not sufficient. What happens if the U.S. citizen refuses to come to the interview? Then the case is going to be denied. That's it. They can, I've never seen it when somebody doesn't show to the interview for them to give that person the green card. No, it's just going to get denied. So now the question becomes, why are they not showing up, right? So if they're not showing up because there's some underlying abuse, well, then you can file for VAWA, okay, or U-Visa if there's domestic violence, like aggravated assault, you know. So yeah, the question becomes why they're not showing up, because if they don't show up, the green card is going to get denied, period, end of the story. And sometimes even people who have like 2 sponsors, like joint sponsor, and the second sponsor doesn't show up to the interview, they might even deny the case, because why the person signed and it's not showing up, you know. So Gonzalez, you find, oh, nice to hear that. Yes, we got 5 people here. Please go ahead and like, please go ahead and share. Emmanuel, I guess you got it, right? So let me know in the comment if you have another question. I'm just waiting for a couple people before I hang up, but I'm going to share with you misrepresentation too, again, because since we're talking about fraud, we have to talk about willful misrepresentation. Give me one moment to drink my water. Yes, I'm going to share the screen with you when it comes to misrepresentation. Let me find it first, okay? Yes, let me share the screen with you when it comes to misrepresentation. Since we're talking about fraud, yeah, I wanted to point out something about misrepresentation. Let's get right into it. Yes, okay. You see, misrepresentation waivers, okay? If you look at it here, right? Yes, an applicant inadmissible for fraud or willful misrepresentation, sorry, may be eligible for a waiver, okay? However, how are you going to get the waiver? You must be able to show that the denial of admission or removal from the United States will result in extreme hardship to the qualifying relative. And in that point is the spouse or the parent of a lawful permanent resident or U.S. citizen, okay? And if you are a VAWA self-petitioner, then you can show extreme hardship to yourself, to yourself, okay? So, yeah. You see, for cases other than VAWA, the applicant must have a qualifying relative who is either U.S. parent or spouse, lawful parent or spouse, or U.S. fiance. You see, U.S. citizen or lawful permanent resident children are not qualifying relatives for the purpose of this particular waiver. That's why I usually tell people this, right? If you have a child that's gonna petition for you when the child turns 21, you have to make sure that you do not have anything as far as misrepresentation is concerned. Because if you don't have a parent or a spouse, then that child will not be able to waive anything for you. Okay? Then the argument will become on whether the misrepresentation question was willful or was material, right? So now we start looking into technicality, okay? So of things, which is really difficult to debate. So that's why we have a video here talking about misrepresentation is the biggest mistake ever to make on an application. Lying on some application is a big no, because at some point, if you don't have a lawful permanent resident spouse or parent or U.S. citizen spouse or parent, you cannot waive that. You see, your U.S. citizen children or lawful permanent children are not qualifying for that type of waiver. Okay, so that's why you don't waive it. It cannot be waived. That's why I don't do it. Okay. And then you have to make an extreme hardship determination as well. And then USCIS is gonna look on whether or not to grant the waiver as a matter of discretion. It's not guaranteed either. So we're gonna go on and on this. There's another waiver when somebody is in removal, when the judge can grant it, but that's for permanent resident, or conditional resident. At the time, they had some type of immigrant visa already, that those are the ones who can use children to waive misrepresentation. But other than that, and they have to be in removal at that point. But other than that, other people, it's not going to work. Children will not waive willful misrepresentation. Okay, let me stop right here because tomorrow we're going to talk about I-751. I guess on Thursday I'm going to talk about why U.S. citizen children is not guaranteed to get a green card. Okay, I-751. Let me write it down. Come on, can't believe it. Anyway, I-751, and then we're gonna talk about why U.S. citizen not a guarantee to get a green card. Okay, and on Friday we might have a good news on Friday. I don't know yet. Just see how it goes. We might have a good news on Friday to share. So let me stop right here and take some questions. Anybody has a question? Okay, Kofi has another question. So yeah, then you have to show a lot of Emmanuel. Then you have to show a lot of affidavit of support to really support whatever you're saying. Really, or those people, those children her children, or they're you're together with you? Are you the stepfather, or what's going on with those children? Yeah, you gotta have a lot of evidence. You gotta have bank account enough. It's not enough. If you're living with parents, then they have to write affidavit of support, notarize, of course. Um, yeah, really, you gotta show a lot of things. In conclusion, it's not bank account alone is not enough. That's just end of the conversation. Okay. If you have children together with, if they are your children, like together, then that might settle it because you can show birth certificate, right? But if they're her children and you're the step, let me give you the link for consultation. Coffee, you don't need to call me. Let me just give you the link. When you're ready, you can schedule a consultation, okay? Just bookmark it. Let me give you the link. You can schedule the consultation. Hold on. Hold on just a second. Yeah, that's the link right there, okay? Just bookmark it on your phone. Whatever you're ready, you can schedule the consultation, okay? Thank you very much. Yeah, so Gonzalez, what happened if the couple does not have a bank account? Well, Gonzalez, finance is the most important thing. When it comes to marriage petition, finance is the most important thing. Unless you have children together, right? If you have the children with the spouse, that will settle a lot of things. Then there's no really doubt, right? It's your child. Well, it really shows valid marriage. But if you don't have children together, no bank account, no filing taxes together, well, that's a big red flag. It's a really red flag. Okay, Gonzalez. And the manual too. Yeah, if you said that you're so poor, the problem becomes who's gonna be the sponsor, the petitioner has to show sufficient income. Are you gonna have a joint sponsor? Because the petitioner has to sponsor the spouse. You see? Yeah. Coffee, Emmanuel, you need a consultation, okay? You really need that. So we can guide you for the paperwork, okay? Because some people think like the green card based on marriage is the easiest one. Trust me, it's not the easiest one. Because some people just file anything poorly and then they end up with a denial. Then they wonder why. You see? Yes, we got other people. Please go ahead and share. Please go ahead and like. And I'm still taking questions. If somebody has a question, just put it in the comment. If you missed the first part of this session, just at the end, please rewatch it because it's very important that you understand how USCIS determined for the marriage. And once you get the 204C under the record, game is over. And you don't want that, really. Especially if you can avoid it, really, to be honest. So if you just got here, please go ahead and share, like. If you missed the first part, just rewatch it. Really, we talked a lot about the matter of SINGH and the matter of PAK, the standards, how USCIS can determine fraud marriage, marriage fraud, and how they can even go back to previous petitions just to come up with that determination. So you have to really be careful how you file those green card with based on marriage with USCIS. You can't just take it like that, you know. Yeah, you really have to be careful and put everything together. So I'm just waiting for some questions. Yeah, waiting for some questions before we hang up for today. But we're coming tomorrow, don't worry. Then tomorrow we're gonna talk about removing conditions on your own when things don't go your way. Yes. So if somebody has a question, please let me know. Anybody has a question, please let me know. Somebody has a question, please let me know. If there's no more question, we can just stop, right? Giving you a couple minutes just to gather your thoughts. And in the meantime, let me see who's liking this video. Yeah, let me know who's liking this video. Yeah, Friday we might come with good news. You never know. So we are waiting for good news because anytime soon, USCIS will decide on some of our cases, specifically waivers. So that's why we're expecting good news. If we don't get good news, like this week, we might get it next week. So doesn't matter because I'm trying to be here every week at every day, Monday to Friday, 6 p.m. probably until the end of this year. It just depends how it turns out. Okay. But if you have a question, just put it. Let me see if somebody has a question. Anybody has a question? Let me see. Yeah, let me see if anybody has a question. You have one child together. Okay. Because she doesn't have a job. But who's going to actually be the sponsor? Yeah, you gotta have a sponsor. Because if the petitioner in question does not have a job, you gotta find another sponsor to join the sponsorship requirement, to meet the sponsorship requirement. Pretty much that's what it is. Okay. So I guess that's it, right? So I guess this is it for tonight. Gonzalez, thank you. You got good questions today. Yeah. If the petitioner does not have the job, you gotta find a joint sponsor, okay? And what else? If you have a child together, that's good. But you gotta find a joint sponsor for it to work. Okay. This is it for tonight. Yeah, this is it. 28 minutes. We'll come back tomorrow again with another subject. Please go ahead and share again. Please go ahead and share with your friends. Emmanuel Coffee. I strongly suggest that you schedule your consultation so we can guide you. Okay. Yeah. Until next time. Bye bye.